I'm now got the pleasure of introducing a pre-recorded session. So this one is pre-recorded for simple time zone reasons. We don't want to ask anybody to deliver anything at the early hours of the morning for them. But we now have a session from Gabriela Kennedy, who's a partner, and she's the co-chair of Maya Brown's IP practice. And she's going to talk around some of the intellectual property considerations that exist around digital product creation, whether that's making digital assets that support the streamlining of the creation of physical products, or those whole new business models that Will was just talking about, metaverse, digital fashion, all these other potential implications. All of that has a lot in store for the way we think about ownership. So I'm going to hand over to this pre-recorded session, after which Janice is going to come back. She's going to quickly wrap up some questions around that, and then she's going to hand over to our final session of the day. You'll see me again as we wrap back around towards the end and bring together some key takeaways. But for now, Alvin and team, please cue up the next session for us. Thank you.
Good afternoon, good evening, everyone. My name is Gabriela Kennedy. I'm a partner at Maya Brown, co-chair of the intellectual property practice. And I'd like to thank Janice Wang and Alvanon for inviting me to share a few things about intellectual property and in particular, IP in the digital age. What I'm planning to be talking about today is take you through some of the basic concepts of intellectual property, and in particular the ones that are most relevant to the fashion industry, namely copyright, trademark, registered designs. And then I'm going to spend a couple of minutes towards the end of my session on some of the issues encountered with intellectual property in the digital realm, and in particular developments such as artificial intelligence and non-fungible tokens. But let's go to what can be protected by copyright. Lots of things can be protected by copyright. Copyright is a property right. Intellectual property rights protect the intellectual output and give the owners and the creators of intellectual property the certain rights and monopolies over their intellectual output. When it comes to copyright, you can have literary works such as books, scripts, and lyrics for music. You can have protection for architectural works, artistic works, and those include jewelry designs, sculptures, paintings, but also garments in the fashion industry in certain, if certain conditions are met. You can also have protection for computer programs that are protected as literary works, and you can also have protection for rights in performance, so the performance that an actor gives on stage. There are certain basic principles and basic things that have to appear for copyright to arise. One thing I would have to note about intellectual property rights in general is that all of these rights are territorial. In other words, if the intellectual property right needs to be registered, it has to be registered country by country. You can have registrations at a more, a bigger level, grouping a number of countries as, for example, in the European Union. But there are certain rights like copyright that arise automatically and they don't need to be registered, save in one or two countries. And those requirements are that the work must be original, i.e. it has not been copied, and you can demonstrate some skill, judgment, and labor. We call it, as IP lawyers, the sweat of the brow. So as long as you have expended some effort to put together the work, it is considered original. And the work has to be recorded in material form, in some sort of fixed form. Interestingly enough, even having a copy of a work in random access memory of a computer is considered as fixation of the work. So Hong Kong, where I am based, and many countries around the world have open qualification systems for copyright. What that means is that once these requirements that you have of originality and recording of the work have been met, you're actually, the work is afforded copyright protection, and that copyright protection, once it has arisen in the country where it was created, gets afforded reciprocal rights around the world. I said that there are exceptions, and the exceptions are, countries like the United States and China, where you have a register of copyrights, and there is no requirement for copyright to arise for you to register the work. But if you want to take enforcement action, you actually need to show a registration. That does not obtain in other countries, all over Europe, all over many other countries in Asia. The other interesting concepts about copyright relate to who is the author and who is the owner. The first person who creates the work, of course, is the author, but the author and the owner can be different. The author can be the owner, but if you are in an employer-employee situation, unless you have contracted otherwise, in most countries, the employer is the owner of the work, even though the employee was the author of the work. There are also differences if the work is commissioned, and that is one that many people have trouble with, i.e., I am paying money for the work, I am commissioning it, and most people believe that because they have paid a lot of money to commission a piece of work, that the copyright in the work belongs to them. Not necessarily, unless you actually by contract specify that you are acquiring the copyright in the work. Otherwise, you just have an exclusive license in respect of that work. The interesting, thing that I think we should spend some time on is infringement. So copyright is a negative right. It gives you the right to stop other people from doing a number of things, like copying the work, putting the work on the market, making it available over the internet, so on and so forth. And there are two types of infringement: primary infringement, if you're actually copying the work, and secondary infringement, if you are selling infringing copies. So you're not the one who has made the infringing copy, but you're selling them. So you can still be liable for copyright infringement, but you need to show that you have knowledge that the work was infringing. And in most countries, there are civil and criminal sanctions, and depending on how egregious the act is, the level of fines can go up. There are limited defenses like fair use and fair dealing. The concepts are slightly different in different jurisdictions, and they tend to relate to research, private study, educational uses, and things like that. I thought I would give you an interesting example of a copyright infringement, because here we're talking about infringement in a fabric design, and you're all dealing with creating fabric and using it in the garment industry. For copyright infringement to arise, you need to actually show substantial copying of a part of the work, and this is a quantitative and qualitative test. So look at the two designs that I have put there. The one on the left-hand side, the one that has a lot of pink, is the original copyright work. And the one on the right-hand side that has the black background is the one that copied the design. So you notice that they've made they put in a lot of effort to make it slightly different. So the flowers have different petals, the background is different, and yet this is a case that went all the way to the House of Lords in the UK. So it went through a couple of decisions, and the House of Lords actually held that copyright infringement is dependent on whether the defendant copied a substantial portion of the original work rather than whether the two works look the same. And they said the overall impression is that the work are the same. So copyright infringement was found in that particular case. Let's look at a few more examples that involve, again, fabric. So we have the first case on the top left-hand corner, which is Unicolors Inc. and H&M. And there you see if you look at it, you say, well, I can see some similarities, but there's a lot of differences. And what the court is saying is small differences in the designs should be disregarded. So they've made the effort to put in small differences. But if you move away a few distances from the fabric, the overall impression is actually the same, and there is actual evidence of willful infringement. And in that case, the H&M was actually fined $850,000 US dollars. If we look at the next example, which is Response Front and Edinburgh Woolen Mill clothing, there we're talking about a wave design of a textured jacketed lady's top. And the court held that fabric is not a graphic work. So there are, in copyright is one of these very, very complex area of law, but it is a work of artistic craftsmanship. The last example that I have on that slide is one that we see a lot, as IP lawyers when we're dealing with infringement in the garment industry, which is that a luxury brand puts on the market a particular style of dress or a fabric, a pattern, and it is immediately copied by fast fashion brands. So that was exactly the case here, Versace and Fashion Nova, copying 3 of their dresses. The first dress was worn by Jennifer Lopez, and you see again, same cut, similar type of dress. So the moral is, when we're looking at, copyright, and by the way, copyright is life plus 50. That's the duration of the length of copyright. And I'm going to move on very quickly to trademarks. And why do I spend some time on trademarks? Because there are many brands that, many trademarks, many logos that have become distinctive and iconic and relate to the garment or footwear industry, and that are being used and borrowed a lot by lots of other brands. So a trademark, in short, lasts forever. It's registrable. It's registrable for 10 years, renewable continuously. Trademarks can be registered or unregistered. If they are registered, you will see this, the R in a circle. Sometimes you see the TM, that indicates that the mark is not yet registered. And if the mark is not yet registered, it shows that you have acquired rights in it. You can take action, but the action is more complicated. It's a common law action in passing off. So if you're using an identical or confusingly similar mark for the same or similar goods without permission, you commit trademark infringement. And let's look at a couple of interesting examples for your industry. Look at the first one involving Adidas, where somebody is a US retailer called Payless willfully infringes the 3 stripes brand and uses 4 stripes or 2 stripes, and the jury awards 300 million in damages, later reduced to 65 million, because they're talking about unlawful tarnishment and dilution of the brand. The one on the right hand corner is Jack Wills, the famous pheasant with a top hat, and here comes the House of Fraser. And their pheasant is slightly different. It's pinkish in color, it's a bigger size, but still the court says that this is a subtle but insidious transfer of an image from the Jack Wills mark to the HF mark in the minds of the consumers, and therefore there is infringement. The Bentley one is an interesting case, because there we're talking with a famous car brand versus Bentley, the top brand that you see in that square, which is registered by a family-run clothing business in Manchester, and that is Bentley Clothing. So Bentley, of course, produces all sorts of merchandising and is putting on the market T-shirts with the Bentley brand, and they think, because I'm putting my B logo and the Bentley word mark, I'm not committing trademark infringement, and yet the court finds otherwise, because that's not their core business. And finally, another interesting example is the famous Lacoste crocodile that has been borrowed and appears on T-shirts available for sale in Marks and Spencer's. And the statement that Marks and Spencer puts out in their defense is that animal prints are incredibly popular with our customers, and last season selected ranges included decorative crocodile patterns. This is the typical defense for most, brands that are being sued for infringement, that it's a decorative feature, and courts have consistently found over time that borrowing somebody's trademark cannot be regarded as it being a decorative feature. Very quickly, I'm going to move on to registered designs. And why do I spend some time on registered designs? Because the law of registered designs versus copyright is extremely complex. I know I only have 25 minutes here, but believe you me that if I were to really delve into this, I would actually need a whole semester at a law school to explain the differences between copyright and registered designs. But let's just, have a bird's eye view and say that registered design protect the appearance of a mass-produced product, the shape, the configuration, the pattern or ornament applied to an article. So what has to happen is that the particular design has to appeal to the eye. That is the test. So we also say it can't be under the bonnet of the car. So I have to be able to see it and immediately recognize it as a special, feature. The other thing that design must have is that it must be novel. You cannot, claim a right if it already exists anywhere else in the world. So even though these rights are territorial, the actual requirement is worldwide novelty. So some examples of such, designs are, of course, the Valentino shoe, where there we're looking at the shape, the configuration, the pattern and ornamentation and the combination thereof. So when you're actually applying to register the design, you have to mark with a highlighter the areas that and the bits that you are claiming your design in. Burberry is one of the very few brands that manages to register as a design their fabric and the pattern for their fabric. And of course, then we have, a lot of registered designs for handbags. The one thing to say, about designs is that if you register it in most countries, it lasts for 25 years. The law is trying to find a way to reach a middle ground, because if you have copyright protection, full copyright protection, of course, is broader and everybody would want it. It's life of the author plus 70 years if you're in Europe, or 50 years if you're in Hong Kong or other places. Whilst the design, a registered design, is just 25 years. And if you don't register the design, you still have some protection at common law for an unregistered design, which is 15 years. Now, to register designs costs a lot of money, and that's why many fashion houses don't bother to register their designs and rely on an unregistered design. It is very seldom that companies actually manage to obtain full protection of life plus 50 for their design. So I'm going to very quickly look at some substantial similarities for designs, and you'll see, there the interesting one, House CB versus Poly. That was egregious copying. Why was it egregious copying? Exactly the same garment. They even used the same models. They even copied their social media strategy, the marketing, the packaging, and the presentation. So it was not difficult for the court to find that there was infringement. The G-Star and Rodi one, you will see side by side. It's what is being claimed is the arc in the garment, and it's exactly the same in photographs. Okay, let's very quickly, because I've only got a few minutes, look at some of the issues in the digital space and artificial intelligence. AI is very interesting because with copyright, you need to have an author. You need to have somebody who's created the work. And I put the picture of the monkey. It's the famous monkey selfie. So a photographer leaves his camera and a monkey picks it up and takes a selfie. Clever monkey. And then that photograph finds itself on Wikipedia. The photographer wants wants to take it down and claims, this is my photograph, I own the copyright. And the court basically says, no, you don't own the copyright because you didn't take the photograph. The monkey took the photograph. And under, you know, the laws of many, many countries, the author has to be a human being. There are some statutes around the world, like Hong Kong and the UK, that actually talk about computer-generated works, where the person who makes the arrangement, puts the program, could be regarded as the owner of the copyright. But artificial intelligence has multiple uses. So the picture on the left-hand side is Project Muse that Zalando, a European fashion online fashion platform, did together with Google to scour a database of 50,000 data sets and look at what creative output for the fashion industry, you know, AI could generate. AI is also used to authenticate genuine products, like the example that is given with the Cartier bag, and that is entropy. And it can also be used as a measurement tool. So that is Nike Fit there, where there's a combination of computer vision, data science, machine learning, artificial intelligence, and recommendation algorithms that together measure the full shape of both feet and is able to recommend the perfect fit for each Nike shoe. So lots of, you know, uses when it comes to artificial intelligence. You all probably have heard a lot about NFTs, non-fungible tokens. What are they, and what's their relevance to intellectual property? What's their relevance with the fashion industry? So an NFT is a unique digital token that represents a digital or physical asset. It's a trading card or certificate that conveys ownership or other rights in the asset. But you have to remember that you must own the copyright, you must own the trademark in order to produce the NFT, or at the very least have a license, you know, to it. And the NFT buyer will get a limited, you know, right which comes with that non-fungible token. Some examples there are the Collezione Genesi by DNG, which was the first luxury NFT collection to include digital and physical works. The NFT wearables for metaverse and avatars, which we saw at the Decentraland in March 2020. And there were loads of brands like Tommy Hilfiger, Dolce, Karl Lagerfeld selling NFT wearables for customers to dress their avatars in. And we even have an NFT in a movie, which is the Gucci Aria celebration. So the last thing that I want to touch on in my remaining 2-3 minutes are to do with the challenges of enforcing IP rights in the digital world. 2 examples, both of them people who produce NFTs without the license of the rights owner. So one is a platform, StockX Vault, that produces these sort of Nike NFTs without any license or endorsement approval from Nike. The other one is somebody who is an artist and puts together a collection of Birkin bags, and they are, you know, all vintage Birkins, and they're offered as NFTs, but they're actually not sanctioned and not approved by the rights owner. So that has been an amazing and whistle-stop, you know, tour through some of the issues relating to intellectual property. There are so many more things that we could be discussing. The area, I appreciate, is very, very complex, and you know, I have just given you a taste of some of the issues that might arise. I would be more than happy to answer your questions, and if you do have any burning questions, may I ask that you direct them to Albanon, and I will be, you know, delighted to answer your questions. And I look forward to perhaps one day meeting in person and being able to participate together with you in a room where you can interrupt me as I'm talking and ask me lots and lots of questions. Goodbye.
Hi, everyone. So I actually got to talk with Gabriela a little bit, and I think the one burning question that I had was, well, what actually happens to the StockX and the Hermes case study? And actually, she said these things are currently still in litigation. So we have one question from Fair Martinelli, who's actually said, well, what if you don't have the resources to register your work in early stage on your business? I'm going to ask her that question because I'm sure there's some technical kind of answer to that. But you know, there was many years ago, the same kind of question came to us: is that what should we do if how do we register all of our work? And one of the things that actually a very wise older friend said to me was, you would be so lucky if you were so cool that you actually got copied. And I kind of took that to heart because part of the question is sometimes that I wonder is you have to be pretty big to, you know, be able to use the courts to your advantage. So there are other things that you really have to do in order to make sure that you are always protected. And there was one really interesting thing that actually came up this week in actually today there's actually a Chinese trademark case victory for for Christian Louboutin and their red sole, which you would have thought, that would be copied all over the place in China. And the big thing that they actually said there was that, well, look, the big thing is that in 2020, when they actually went to the Chinese regulators actually denied its application on the grounds that the trademark lacked defining features because a red sole was just red sole. They didn't actually link it to Louboutin. However, because Christian Louboutin kept actually forcing the issue and actually encompassing their marketing initiatives in the last decade had actually made local shoppers actually link their red sole design with the brand. This became a critical factor that allowed them to actually get a favorable ruling. So there's quite a lot of stuff in there to unpack. But the one thing that Gabriela definitely wants us to all know is that if you do not have the rights, just because there's a new medium for you to put out there, it doesn't mean that you can actually make a Birkin bag and put it in the metaverse. So just beware of actually, there has to be original work, which, for the fashion industry is a little bit easy to talk about.